Thank you, Mr. Speaker. I'm pleased to rise in the House today to engage and speak to Bill C-26, an act to amend the Criminal Code for citizens' arrest and the defence of property and persons, commonly referred to as the Lucky Moose Bill. First, let me begin my statements by highlighting the incidents which have led to the introduction of legislation of this kind by both the government and by the great member from Trinity Spadina. On May 23, 2009, Mr. Speaker, David Chen, owner of the Lucky Moose Food Mart in Toronto, apprehended a man, Anthony Bennett, who had stolen from his store. After Bennett was initially caught on security footage stealing from the store, he returned an hour later. At that time, Chen, who was 36 and had 2 employees, tied up the man and locked him in the back of a delivery van. When police arrived, they charged Chen with kidnapping, carrying a dangerous weapon, a box cutter, which most grocery store workers would normally have on their person, assault, and forcible confinement. Crown prosecutors later dropped the kidnapping and the weapon charges, but proceeded with the charges of forcible confinement and assault. Although Anthony Bennett, the suspect in question, ultimately pleaded guilty in August of 2009 to stealing from the store and was sentenced to 30 days in jail, the Crown moved ahead with the charges against Mr. Chen and his employees, as under the Criminal Code, as it is currently written, a property owner can only make a citizen's arrest if the alleged wrongdoer is caught in the act. Obviously, the circumstances in this case, where the suspect returned to the scene shortly after the offence was committed, exposed a fatal flaw in the legislation, which has led us to this point. It is also important to note that this suspect in question had stolen repeatedly from the same store, so this was certainly not a case of mistaken identity. We can be assured of that, Mr. Speaker. Eventually, after a 1.5-year-long ordeal with the courts, Chen and his 2 co-accused were found not guilty of the charges of forcible confinement and assault on October 29, 2010. Obviously, Mr. Speaker, the process of a lengthy trial was distressing for Mr. Chen and his family, while also tallying significant administrative costs borne by the taxpayers and tying up the valuable time of police, prosecutors, and the courts. In response to the ongoing concerns which New Democrats heard from individuals across the country regarding a citizen's ability to make a lawful citizen's arrest, in September 2010, the New Democrat MP from Trinity Spadina introduced a private member's bill to amend the Criminal Code in order to protect individuals like David Chen from facing criminal charges. Mr. Speaker, New Democrats have consistently welcomed the government's decision to incorporate the member from Trinity Spadina's proposals into their legislation, first tabled in February of 2011 during the 40th Parliament and now again in the 41st Parliament. Let me now move to the specifics of the bill in order to parse out what is actually being proposed by the government at this juncture. Let me begin with the sections dealing specifically with citizens' arrest. Currently, under Section 494(1) of the Criminal Code, any individual can make an arrest without a warrant of a person whom he or she find to be committing an indictable offence or believes on reasonable grounds has committed a criminal offence and is escaping from and freshly pursued by those with lawful authority to pursue the suspect in question. Under Bill C-27, this section of the Criminal Code relating to citizens' arrests will remain unaltered. Therefore, the amendments being proposed apply solely to Section 494-2, which applies to the owner or other persons in lawful possession of property or a person authorized by the owner of lawful possessor. Currently, such a person may make a warrantless arrest of a person whom he or she finds committing a criminal offence on or in relation to that property. The proposed amendment would subsequently allow such a person to make an arrest within a reasonable time after the offence is committed. Under the amendment, business owners or persons under their delegated authority would be rightfully allowed to make an arrest if he or she believes on reasonable grounds that it is not feasible in the circumstances for a police officer to make that arrest. The final piece of Bill C-27 as it relates to citizen's arrest is the addition of the new section, 494-4. This section specifically clarifies that a person who makes an arrest under Section 494 is a person who is authorized by law to do so for the purposes of Section 25 of the Code. Essentially, the purpose of this amendment seems to be intended to denote that although the use of force is authorized in a citizen's arrest, there remains limits on how much force can be used. So, Mr. Speaker, for those who are not fluent in legal jargon, essentially these amendments will permit citizens' arrests without a warrant within a reasonable period of time after a criminal offence is observed. This means that in the case of Mr. Chen, he would have been acting within his rights as a business owner to protect his property by detaining Mr. Bennett. I think that by removing the onerous provision which require the citizen's arrest to occur while the offence is being committed, we are moving in the right direction, Mr. Speaker, to ensure that business and property owners can properly assert their rights to defending their property. I've heard from many small business owners in my great riding of Sudbury who were shocked at the prosecution of Mr. Chen and they support these changes, which I must again reiterate have been proposed from parties from all sides of the House, Mr. Speaker. I think it is vital that we provide citizens the lawful power to detain offenders where the situation warrants, and I think these amendments to the citizens' arrest sections of the Criminal Code strike an appropriate balance. In addition to amending Section 494-2 of the Criminal Code, this bill and its predecessor, C-60, also proposes amendments to the sections in the Criminal Code dealing with self-defense and defense of property. This bill, Mr. Speaker, proposes a substantive overhaul of the statutory language pursuant to Sections 34-42 of the Criminal Code. 5 of these sections are from the original Criminal Code of 1892, and the courts have indicated that there are problems with clarity in regards to these sections. For example, the self-defense provisions in the Criminal Code have been described as confusing and have been much criticized as a result. In the case of R versus McIntosh, Chief Justice Lammer stated that Sections 35 and 34 are highly technical, excessively detailed provisions deserving of much criticism. These provisions overlap and are internally inconsistent in certain respects. The judgment of the majority in McIntosh, however, has itself been called highly unfortunate for further muddying of the waters around the self-defense provisions. The majority in which McIntosh held that Section 34-2 of the Code was available as defense when the accused was the initial aggressor. The argument was that Parliament must have intended for Section 34-2 to be limited to unprovoked assaults because it enacted Section 35 to deal specifically with situations where the accused was the initial aggressor. This argument failed, Mr. Speaker. The ruling seemed to go against the history of self-defense law, which pointed to a sharp distinction between unprovoked and provoked attacks. This bill would remove the current sections 34 through 37 and replace them with a new self-defense provision which would apply to all offenses. The new provision would ensure that a person would not be guilty of an offense if they believe on reasonable grounds that force or a threat of force is to be used against them or another person, that any acts committed are for the purpose of defending or protecting themselves or that other person, and that the act committed is reasonable in circumstances. The bill also lists a number of factors that may, among others, be considered when determining whether or not the act committed was reasonable in circumstances. This list includes, among others, imminency of a threat, the use of a weapon by the aggressor, the size, age, and gender of the aggressor, and the history of the relationship between the actors. Furthermore, Mr. Speaker, the bill specifically states that the defence is not available when responding to threats from people acting in their official capacity to enforce the law, for example, police officers, unless the accused has reasonable grounds to believe that that person is acting unlawfully. Sections 38 through 42 of the Criminal Code as they stand refer to the legal rights of people to use force legally in protection of their property against theft or damage. The first two sections refer to the defense of movable property, and the latter three sections to real property and dwellings, as the Code permits the use of more force to defend real property than movable property. The Criminal Code also recognizes that it is often difficult to distinguish where defense of property ends and self-defense begins. I know that as a father and a husband, if someone were to break into my home, my first concern would be for my daughters and my wife, not for my home and the belongings. Fortunately, the Criminal Code recognizes this fact, Mr. Speaker, and because of this, it explicitly outlines situations where self-defense can be evoked, such as when a trespasser refuses to leave a property. I think it's important at this point, Mr. Speaker, to give a brief outline of what the 5 sections of the Code as they stand authorize. Section 38 provides that a person can take back possessions from a trespasser, provided that they do not strike them or cause bodily harm, unless the trespasser continues to attempt to retain or take the items. At this point, the trespasser is deemed to have committed an unprovoked assault, and the provisions regarding self-defense come into play. Section 39 provides a defense to an individual using force to defend property being taken by someone else with a legal right to it. Subsection 1 of the provision refers to someone defending property to which they also have legal right to, and subsection 2, Mr. Speaker, to someone defending property to which they have no legal right. It appears that the aim of this section is to encourage people to reclaim property through legal means, rather than through force. Section 40 allows an individual to use as much force as necessary to prevent someone from breaking into their legally owned home. Section 41 sets out the amount of force an individual can defensively use to prevent or remove a trespasser. Like Section 38, Mr. Speaker, this provision deems a trespasser to be committing an unprovoked assault if they resist attempts to prevent or remove them, and therefore brings into play the provisions applying to self-defense. The final provision on this issue, Section 42, provides information regarding the force that can be used when taking back possession of real property from trespassers, and the effect of a trespasser assaulting someone who is attempting to take back legal possession of their real property. Under the bill being considered by the House today, these 5 sections would be repealed and replaced with a new single provision for the defense of property. Under this provision, an individual will not be considered guilty of an offense if they believe on reasonable grounds that they are peaceably possessing property or assisting an individual who they believe possesses the property. Another point, Mr. Speaker, believes on a reasonable ground that a person is about to enter, has entered, or is entering the property unlawfully, is trying to take possession or has taken possession of the property, or is about to damage or is in the process of damaging the property, are acting to prevent or end such action, and, Mr. Speaker, and that the act committed is reasonable in such circumstances. These provisions, Mr. Speaker, will not apply if a person who does not have legal right to property uses force against someone with a legal right to it, or, like the self-defense provisions, to any acts committed against people with the authority to enforce the law unless the person believes that they are acting unlawfully. Having considered what this bill would do to the Criminal Code regarding self-defense and protection of property, it is now important to consider whether these changes are desirable and constitute good public policy. Whenever looking at changes to the Criminal Code, A good place to look is to the organizations that represent the organizations that enforce the law. The courts have already indicated that the language in these sections of the Criminal Code require some clarification, so it's important that we work to clear up such problems. However, Mr. Speaker, we must ensure that any changes has a positive effect, and for that reason, I am looking forward to following this bill at committee stage, where I am hopeful that the legal experts will be on hand to shed more light on the ramifications of these changes. Both the Canadian Associations of Chiefs of Police and the Canadian Police Association, which represents 41,000 frontline police personnel across Canada, have been generally supportive of the changes brought forward in this bill in terms of self-defense and protection of property. However, they have also stated that they have some reservations and some concerns. Again, I look forward to these organizations speaking to this bill at committee to hear if there is any way that we can address the concerns that they have brought forward, Mr. Speaker. I'm sure that both the police chiefs and the frontline officers share my concerns that we do not want to make changes to the criminal code which would encourage people to participate in vigilante justice or which would encourage people to put their own safety at risk. While I know this is not the intention of this bill, Mr. Speaker, I also look forward to hearing from people with a background in sociology and in criminology to ensure that this will not be the case and to strengthen the bill in this regard if it is required. In conclusion, Mr. Speaker, I am happy that the government has brought forward this bill, and I'm happy to support it at second reading. The issues of citizens' arrest, self-defense, and defense of property are all issues which will need to be clarified in the criminal code, and I'm happy that we have this opportunity to do so, Mr. Speaker. I'll be following this bill very closely through the committee stage, and I hope that the government will be willing to work with the NDP to ensure that we are able to have the strongest legislation possible ready for debate at third reading. And I will take that acknowledgement from my colleague on the other side of the House as something that we all look forward to and is making Parliament work, Mr. Speaker. And with that, I look forward to questions and comments. Thank you, Mr. Speaker.